we will not be monitoring the chat function during today's presentation. Also during the presentation, you will see some questions pop up during the part of the polling section, and we want you to share your answers with us so that we have good feedback. The webinar has been approved for 2 hours and of the manager's credits, and if you need a certification of that or certificate of that, please email Jackie at jaclyn@cai.org. And with that, Dave, you need to put your cup down. I will introduce Dave Ramsey from Becker Lawyers, and he has been our historian on the committee. And Dave, I'm going to ask you to please brief us on Radburn.
Okay, happy to do it. Let me just start by taking you back a little. As Barbara said, having been around as long as I have, I'm somewhat of a historian on this. This doesn't go back that far. So as many of you are aware, if not all of you, back several years ago, Senator Gordon worked with us in doing a new law dealing with elections. It was Senator Gordon's effort, but he fortunately reached out to us. We participated with him, and we ended up drafting what we thought was a pretty balanced law concerning elections of board members. Now, that statute was made part of the Planned Real Estate Development Full Disclosure Act, PRED for short. It did not add any new rulemaking authority in the Department of Community Affairs, but the PRED Act, originally a developer disclosure bill, did contain provisions for rulemaking. So DCA took the opportunity last year to publish a whole raft of new rules concerning both the Radburn election law, but also creeping into other things as well. So we saw those rules, we, the LAC, saw those rules last year. They were preliminary, they were open for public comment. We commented on them with a 25-page letter because we found a lot to object to. And you probably heard about that because I know there was a news put out from the LAC about this. We have been waiting since then to see what DCA would finally do. And just this past Tuesday, I believe it was, they released the rule, of course, right in the middle of this pandemic, while we're tied up in so many other things. They released the final rule. The bottom line is that they made some tweaks in some areas, but our substantial objections, our big objections, were not addressed. Now, before I get into just a couple of the things, because the time limit does not allow me to go into depth, but before I get into it in just reading off a couple of the items that are in there, the LAC will be meeting about this. The LAC will be looking at options. Those options include seeking assistance from legislators, because legislators can overrule what the DCA has done, or even perhaps bringing an action against DCA because we believe that many of the rules that they put forth are beyond the scope of their authority. That being said, let me just give you the highlight of the top 5. If I have time, I'll throw in another one. But starting with 5, they put forth a rule about a developer holding a seat on the board so long as the developer was selling units in the regular, ordinary course of business. This is going to apply more to associations in transition, of course, but we pointed out that that terminology, ordinary course of business, regular course of business, selling units, is undefinable, and that developers have often used that provision to maintain a seat on the board, often problematic, for an extended period of time, thereby denying an owner that seat on the board. Interestingly enough, the DCA said, yeah, we pretty much agree with that comment, but we're not going to make that change right now. We'll look at that sometime in the future. Okay, the next one. You must, according to DCA, if you have affordable housing units in your development, and I should immediately start by saying CAI does not in any way, shape, or form oppose affordable housing. The problem is DCA put in its regulations that you must amend your documents if there's no seat reserved on the board for an affordable housing unit owner. You must amend your bylaws to reserve a seat for an affordable housing owner. Now, many documents do that anyway. That was part of the original documents, but many do not. The problem we pointed out to DCA was while you're reserving a seat for affordable owners, frequently nobody from the affordable units run for that seat, thereby leaving that seat open. So if you had a 5-member board, you'd end up with a 4-member board. And nothing prevents affordable housing owners from running for any seat on the board. So you really end up with a strange situation because the other seats aren't reserved to market priced units. Only one seat's reserved, and that's for the affordable owners. DCA, by the way, there is nothing in the PRED law or in the Radburn election law that authorizes that. Number 3 on my hit list, requiring notice to all delinquent owners at least 30 days before the annual meeting that they are delinquent, that they can pay up to 5 days before the meeting, and that they can ask for ADR. So the good standing provision in the PRED Act says if you ask for ADR and the ADR has not been heard, you are still deemed to be in good standing. What this essentially does is it would allow delinquent owners to vote because they could ask for that ADR. The ADR process probably wouldn't be completed. And then they'd be entitled to vote despite the fact that they're delinquent. Nothing in the Act supports that. Number 2 on the hit list, the requirement that all tallying of ballots at the annual meeting must be open to observance at the annual meeting. Now, for many of you, you may say, well, that's not a big deal. We don't have hotly contested elections, or, you know, most of the time we have no contested elections. And for you, it may not be a big deal. But if you're in an association or a building that has hotly contested elections, you know what I'm talking about, because it will literally cause a disturbance at the annual meeting when you're trying to conduct the balance of the annual meeting, to have everybody grouped around the people who are the judges of the election while they try to count the ballots. No change despite our request for a change. And number 1 on the hit list, by far, fines for any violation of the rules by board members and managers. So all of you volunteer board members would, under these rules, be subject to fines. Fines up to $5,000. Now, in honesty, we wouldn't expect to see fines in that amount, but any fine for a volunteer board member is intolerable to CAI, absolutely intolerable. So our position is they never had the authority to adopt that. The fine provision that is in the PRED law was clearly put in when the PRED law was limited to DCA reviewing developer applications for registration and public offering statements. It makes some sense for developers to be subject to fines if they misrepresent or mislead or fail to follow the PRED law. To suggest, however, that those same fines are applicable to board members is frankly outrageous. So those are the issues there. And with that particular matter, as I say, we will be discussing it further. We will keep you advised. But in the meantime, we have to tell you it's the law. So if you have an annual meeting coming up, speak to your legal counsel. Make sure you're in compliance to the degree you possibly can be. Make sure you're in compliance because we don't want to see anybody in the meantime be subject to fines. The second part of this that I was asked to comment on during this part of my presentation was the Ukiah law. very quickly, the Ukiah law passed both houses of the legislature last year. It was vetoed by the governor pursuant to our good friends at the Department of Community Affairs objecting to it, even though they knew 6 months before the law passed that the Senate had overwhelmingly approved it. They never said a word to us. They never asked to sit down with us, never suggested to do anything. And now we're back again this year, and we have just been told by our lobbyist that the bill will be up for a hearing in front of the Senate committee a week from today, next Thursday. We remain committed to the Ukiah bill. We remain committed to working out any issues over it and to see it finally become the law of New Jersey. Just as a last note, it is a law which will replace large parts of the Condominium Act, large parts of the Pred law, and bring all associations under one common umbrella with the same rules and requirements as all other associations. And with that, Barbara, I turn it back to you.
Thank you, David. We do have a question, and that is, if your association is in the middle of a board election, do the recently issued DCA rules have to be followed for the election to be valid?
So now, of course, whoever's asking that question should get their own counsel's advice. However, without this being legal advice, I will tell you that our position, because we have associations in the same situation, is whatever you did prior to the rule coming down should not be contestable. You are already following law, assuming you met the notice requirements that are in the law, assuming you went out and got nominations as required by the law. But anything that is still applicable, for instance, the counting of ballots in an open meeting, in the annual meeting, for instance, would still have to be complied with. So comply with what you can, and I wouldn't worry about what you did prior to the new regulations.
Okay, one more, David, and that is
Sure.
regarding the election ballot counting. If they're using an outside firm to receive and count the votes, what advice do you have with regard to that?
So in terms of using an outside service, that's fine. You certainly it's totally fine to do that. They, however, will have to have people at the meeting, assuming this wasn't totally an electronic vote, because DCA did acknowledge that electronic votes could not be counted in open. And I would doubt that the association has only electronic votes. So any votes that were cast by absentee ballot, proxy, or at the meeting would have to be counted in an open meeting. Now, of course, a lot of people are asking, well, we're having a virtual open meeting. And that, of course, adds a little more complexity, because you have to allow people then to view the judges of the election who are actually doing the counting. Obviously, they're not going to be physically present to see that. But although normally we would have put them in a separate Zoom room to let them do their work, now they'd have to be open to being seen while they're doing the counting. And that's going to take a little working out to get that arranged.
Thank you. Okay, next.
Barbara, I'm going to ask David one quick thing before we move on to me. David, we understand that we do have a period of time within which to challenge these new regulations, and I just want to assure everybody that we as the LAC and maybe others around the state are certainly strategizing on what our next steps are. Can you comment on that real quick, Dave?
Yeah, I think, and I have not spent a lot of time looking at this, but I believe we're subject to the same 45-day rule that applies to many governmental actions. We will certainly take a closer look at that in plenty of time to make sure that that is the relevant time period. But certainly we will have made a decision well before that as to next steps.
Great, thank you.
Okay, thank you. Next, I'd like to introduce George Graytrex of Hill Wallach. He's the chair of our Legislative Action Committee, and he's going to speak on the debt collection bill.
Thanks a lot, Barb, and good morning, everybody. Thanks so much for being here. It's very gratifying to know there's this many folks that want to know what we're doing and what's going on out there. Before I start talking about my topic, I did want to make sure that all of you knew who you were looking at on the screen here. Mike Pesci and Barb Drummond and Matt Earl and Chris Florio and I and Liz Commando also are all members of your Legislative Action Committee, and I thank them for being here today and participating. I also thank all of the members of the Legislative Action Committee for all of the great volunteer work that they do on behalf of all of us who live and work in common interest communities here in New Jersey. And certainly, last but not least, I wanted you to know who Michelle Jaker was, who's in the upper right-hand corner. Good morning, Michelle. Michelle is our professional lobbyist. She works for a company called MBI in Trenton, and she is our eyes and ears on the ground in Trenton. And she gives us great guidance, and she's our go-to person when we need to know what's going on the inside. So thank you, Michelle, also for being here. And by the way, you're unmuted, Michelle, during the presentation. So whenever you hear us say something wrong or can give us some pointers, let us know.
Will do.
Great. All right, folks. One of the important issues that we on the LAC have been following for really a couple of months now are the efforts around the country to impose debt collection restrictions, moratoriums. There have been a number of states around us and in the country that have in fact imposed those kinds of debt collection restrictions, notably Massachusetts, Illinois, Washington, I believe Florida. And so we believed that there was a strong possibility that that type of effort was going to come to Trenton. And sure enough, it did. If you'll recall, back in early April, a bill was introduced called the COVID-19 Financial Security for Consumers Act. It's known as S-2330, and the companion bill in the Assembly is 3908. It was introduced by Senator Poe and Assemblywoman Jacey, and effectively it would have applied to all common interest communities in our state as creditors, as well as law firms and other collection agencies as debt collectors for common interest communities. So why is that bad? Well, it's bad because it would have prevented most of our debt collection efforts on behalf of associations to try to collect overdue assessments. Things as simple as sending out a demand collection letter, or filing liens, or filing money judgment lawsuits to try to collect the money that is due to our associations. And what was really troublesome about this bill was that not only did it stay in effect during the state of emergency, but then it was proposed to be in effect for another 120 days after the state of emergency was lifted. So as I said, it was introduced on April 9th, and it was scheduled almost immediately for a vote in the Senate on April 13th. And you may remember that you got a very important member alert from us saying that this bill is going to be voted on, and it's bad for us because it will prevent us from collecting the overdue assessments that we so much need to continue work on behalf of our common interest community. So we sent out an alert. You all were terrific in the way you responded. We did hear, and Michelle will probably tell you that we heard that there were many calls and letters that were received by legislators. And sure enough, on the day before it was going to be voted on, it was pulled from consideration. And I think in large part because of the strong response that you all gave us. It was then about a month later listed in committee in both chambers, and we submitted testimony to both committees, and I'll read it to you. It's short, but it kind of it captures the message that we were trying to get through. I speak on behalf of nearly 1.4 million citizens who live and work in the 6,700 common interest communities here in New Jersey. Unlike banks, credit card companies, and other commercial businesses, common interest communities are nonprofit corporations. As such, we bring only enough revenue in to provide services to our residents. If community associations are prevented from collecting overdue common expense assessments from those homeowners who do not timely pay them, it will jeopardize the association's ability to provide the essential services necessary to protect the health, safety, and welfare of all of our residents, such as sanitation, janitorial, property maintenance, to name only a few, placing these residents at an even greater risk of exposure and harm. The bill, without amendments, while well-intentioned, would prevent community associations from collecting the full measure of funds that they need to carry on the daily administration and caretaking of these residential communities and those who live and work in them. This would be devastating and dangerous for these communities. Likewise, the downstream impact on the many vendors who provide these essential services would be just as devastating. So as a community of neighbors, we already work with and support our residents who have suffered financially as a result of the COVID-19 pandemic. For instance, if a resident has lost his or her job, our communities are quick to offer a variety of assistance, including waiver of late fees, payment deferrals, and modified payment arrangements. To restrict all collection activities across the board is respectfully a disproportionate response to an issue that has not yet been shown to exist in our communities. We think that that message was well received because the bills themselves were then amended to pull out of the original bill the main part of the restrictions that would have prevented us from doing our normal collection activities. So we were gratified to know that. They were successfully voted out of committee without the bad parts in it. And Michelle tells me that the next voting session is May 28th. Michelle, do we know whether or not either of those bills are listed yet for a vote in either of those chambers?
No, and there's committees on May 28th, so it wouldn't have an opportunity to be voted on until June 15th. And it is, you know, the next step would be a full vote in both the Senate and the Assembly. Yeah, at this point in time, you know, this is what we call in Trenton, by the very technical term, is a really big bill. And it's kind of gotten weighed down. There's a number of sections in it related to health insurance coverage for COVID testing and treatment. It's got consumer reporting sections in there. And you could probably hear my dog shaking in the background, so I apologize for that. It's got sections in there on consumer data reporting that brought in the banks and some consumer reporting entities. And then it had this consumer debt collection piece, which brought in anybody who is extended credit. It's brought in, you know, CAI, lumber yards, you name it. So a lot of people who were interested in it. When the debt collection piece of it came out of the legislation, then it brought in the consumer rights groups who were very much in favor of the bill and now are opposed. So last I've heard, the legislature really is split down the middle on this. A handful of legislators supported the bill with the debt collection piece in it and don't support the bill with it out. And then another handful of legislators supported the bill, would only support the bill if the debt collection piece is out of it. So a lot remains unknown at this point, and we have a couple more weeks before they can act on it. But we'll be certainly working on this one pretty actively.
Great, thank you. Another bill that would have affected our ability to collect overdue assessments is a bill that came out that was introduced by the same senator, Senator Poe, and that number is S-2423. That bill was captioned as concerning exemptions from bankruptcy proceedings, but a closer look at the bill shows that it actually went further than just dealing with the bankruptcy law here in New Jersey. It would have actually expanded the list of personal property that's exempt from seizure in bankruptcy proceedings, but it also would have amended existing law to increase the value of personal property that is exempt from seizure from $1,000 to $15,000, and also made bank accounts under $5,000 exempt from seizure. So for those of you on the call who do debt collection work on behalf of your associations, you know that that would have a significant impact on the ability, on our ability to collect those assessments that are due to our associations. That bill was introduced on May 7th, and it had been immediately scheduled for a committee hearing on May 12th, and your LAC submitted concerns and opposition to Senator Poe and her staff, as well as other selected legislators. And again, fortunately, our message was heard, and that bill was pulled from consideration in that committee. I have not seen it surface again. Michelle, have you? Do you know whether or not that is going to see the light of day anytime soon?
Yeah, it was as George said, it was sent directly to the Senate floor. I think one of the issues, transparency has never been a virtue of the legislature, and now that we're doing all of this remotely, it's even harder. So yeah, it was introduced and sent straight to the Senate floor before anybody had an opportunity to look at it. They were moving it that quickly because they thought there was no opposition to it. There was no opposition to it because nobody had a chance to look at it. So yeah, it was once they understood what this bill would do and the concerns, they did resend it to committee. So now it sits in the Senate Budget and Appropriations Committee. I believe they haven't announced yet, but there's likely a hearing on the 28th. I'm not sure this bill will be on that agenda just because there are a number of concerns, but we do need to keep an eye on it.
And we will. Great, thank you. And finally, with regard to federal legislation, I'll try to do this quickly. The CARES Act, that was the third stimulus package, when it was first introduced last month, actually had a debt moratorium provision in it, but that was negotiated out before it was signed into law by the president. Now we understand, well, we know that the fourth stimulus package, which was approved by the House of Representatives just a couple of days ago, that's also known as the HEROES Act, again contained the debt moratorium language in it as approved by the House of Representatives. There are two standalone bills that they took that language from. One is S-3565 and the other is HR 6423. Those were the standalone debt collection moratorium bills. We understand, as you probably heard in the news as well, that both the Senate Majority Leader and the President say that the bill was DOA in the Senate. It's unlikely that that bill in its current form is going to move anywhere in the Senate. So at this point, there's little chance that that nationwide debt collection moratorium will be in place. So really the lesson to be learned from all of this is that I'm going to implore all of you to be flexible and reasonable in your collection efforts. If we ask that you work with those members of yours that need help, the ones that reach out to you and say, hey, I lost my job, or there's a family member sick with the virus, whatever that is, if they're asking you for help, we ask you to work with them. Not saying that you need to do an across-the-board policy with regard to debt collection, but certainly we don't want stories filtering to our legislators that we as an industry are being over-aggressive in our collection efforts, especially during a time such as this. So I appreciate the opportunity to speak to all of you. If there's any questions, what do you think?
We'll get to those in a bit, George.
Okay, great. Thank you.
Thank you. Okay, next up is Chris Florio from Stark and Stark. Chris is our Vice Chair of the Legislative Action Committee, and he's going to speak on some of the recent executive orders. And Chris, there are a few questions here waiting for you.
Okay, well, thank you, Barbara, and good morning, everyone. Just as an initial comment, just keep in mind that the orders I'm going to discuss, for the most part, they all have some common threads to them. And the common threads typically are the social distancing that has to be engaged in still, sanitation where need be, in some instances, limitations of the number of folks who are involved. So I'm not going to get into the weeds of each and every single one, only because of A, time constraints, and two, they're available if anybody wants to read them. But I would suggest if anybody really wants to see where we are right now, because we know this week the governor has given us a three-phased, basically a three-phase-in as to when this economy is going to get open. And we're essentially entering and are in most respects, phase one. So if you just Google Governor Murphy's phased-in for opening New Jersey's economy, you'll get a nice chart that comes up. And I'm just going to give you briefly what the first phase says, and then I'll get into some of the orders. That state and county parks can open. In June, I know you were looking for this, June Bretts. The state and county parks are open, non-essential construction, curbside retail, drive-in activities, we'll talk about that in a moment, beaches, just in time for the Memorial Day holiday, and elective surgeries. So we are in phase one. So we all know in mid-March, the governor essentially shut down the economy, except for a number of essential businesses, emergencies, and things like that, all the stay-at-home orders that we were dealing with. So last Wednesday came Order 142 that essentially allowed the non-essential construction to come back into effect, curbside pickup for retail, drive-in type activities of recreation. That all commenced as of this past Monday, on the 18th. The other thing you might be interested in taking a look at is there are some areas in New Jersey where you see drive-ins. There's only one drive-in theater left in New Jersey, and that's way down in Vineland. But there's a number of them that are popping up, I guess, for business purposes. So you've got some entrepreneurs out there. So if you go online and you want to look for a drive-in theater that's temporary, you can take a look online. So that was Order 142. Last Thursday was 143, and this opened up the beaches. All right, the lakes, things of that nature. That takes effect tomorrow. That's where we started to see folks on the boardwalk, which was causing a little bit of consternation, I know, for government officials. It doesn't mean that the amusements or the restaurants and the like on those boardwalks are open. They're open for curbside pickup. So you're not going to be able to go in and do the dine-in and all the good things that we're looking forward to. So that's your beaches. And again, there's the social distancing aspect and things of that nature that the local officials will have to deal with. We heard the governor talk about last Friday, Order 144, the intent of our primary, which has been moved to July 7. The intent there is to have it to be predominantly done by mail-in ballot, although the order itself has language that requires at least one polling place in each county to be open for folks. And that again would require all of those general social distancing, sanitation aspects that I started in my discussion about what needs to be done. Elective surgeries. That was an Order 145 that the governor issued last Friday. That starts on May 26th. So all of those folks who need to do elective surgeries, of course, you check with your doctors. The Department of Health will be involved on that one in terms of what can and can't be done. So just, again, if you're going to have an elective surgery, talk to your doctor about that. Last Saturday, Order 146 came down. This dealt with charter fishing and vehicles for hire, watercraft rental, surfboards. What's unanswered for me, although I believe if you look in the orders a little bit deeper in terms of the rental of watercraft, it allows curbside pickup. One of the queries would be, well, what does that mean if I'm going to just, be down at the shore and I'm going to just take it out on the bay? And Michelle, I'll look to you if you agree or disagree, but I believe as long as they can deliver that curbside or waterside, dockside, right, probably is allowable under the way that order is written, although it doesn't say that with any specifics. So just be mindful of that. And then the last one that came out on Monday is really the one that for you golfers out there, including myself, that we were all waiting for. Michelle knows I've talked about this one for a long time, is get the lobbying group out there. Golf has been allowed for a while as a twosome. It's now, as of Tuesday, been allowed for a foursome. There are other activities that are allowed, and I'm going to just read those briefly, which will be archery ranges, batting cages, golf driving ranges, horseback riding, shooting ranges, and tennis clubs. Now, the golf is open now. The items that I just discussed will be available as of tomorrow, 22nd, just so that you're aware of that. And again, I just want to emphasize, there's going to be the requirement of social distancing, what the employers of these entities must do in terms of sanitation. So it's not a all hands on deck and we can do anything we want. Now, I know just listening to the news, the governor's been talking and is getting questions about phase 2. And I'm not going to go into that in detail, but I just wanted to read to you what that would be, which would be expanded retail, outdoor dining, indoor dining at reduced capacity, limited personal care, museums and libraries. And Michelle might be able to comment on this, but the news at least said that in the next couple of days, the governor was going to talk a little bit more about that. I don't think that means we'll have a date certain, but everybody is wants to get moving to phase 2, but we are in phase 1 at the moment. So Barbara, that's a brief update on the orders to date as I know them. If I missed any, Michelle will certainly correct me.
Okay, thank you, Chris. We have a question here about residents who might gather this weekend at some of the amenities for the, that are in our communities. And the concern is, should board members keep these areas closed, or are they allowed to use them? They have tables and chairs that are spaced apart, but what advice can we give to board members who are looking to make these difficult decisions?
Well, part of the problem, Barbara, as we know it and we've heard, is anybody, and this again, unfortunately, it's the legal aspect of it, can litigate over anything. And the problem in what we're hearing from our insurance experts is a lack of insurance coverage for something like that. So of course, as an attorney, I've got to couch any response that I give to that type of a question to consider that potential. Now, of course, then the next issue is, well, can that person prove exactly where they got it, which is going to be difficult. And as Dave Ramsey had said earlier, of course, don't take this as pure legal advice, ask your own attorney for that. But unless you're going to be able to do this in a responsible way with social distancing, all right, the sanitation, all these orders that we're hearing that these entities that are open to the public have to do, why would the private be any different? And so the issue for me becomes, and I know that there's maybe a question out there, so I may as well get into it a little bit, about the pools. All right, can we reopen the pools? Problem I have with the pools is we always have an endemic problem with the complaints we hear every year with the 16, 18, 20-year-old lifeguards just checking badges. And what's the expectation if that responsibility is placed on them to do social distancing, all right, and sanitation? So unless we've got some comprehensive way of dealing with this, I'm not a big fan of opening up anything until we get further into environment of the economy and the environment being positive, no pun intended, in that regard. But I would still wait and see a little bit. I know it's difficult with a holiday weekend, I get it, but unless we can do something that is going to be strenuously enforced, I'm not a big fan.
Michelle, what do you hear about pools? When's the governor going to talk about them?
I was just going to weigh in because after golf opened, now the question I get every day, 4 times a day, is pools. And it's not just me getting that question. I know that the governor's office has a call daily with local elected officials, and pools has been raised every single day on that call as well. My guess, and I'm not, sitting in the governor's office, while they make these decisions, but my guess is that they haven't quite figured out how to open pools yet. So we have been told probably for the past week and a half that an announcement on pools would be imminent. And the fact that it hasn't happened yet, really just means that they have concerns. And they are trying to tie up, any outstanding questions and issues related to that. So, as it relates to pools, there is going to be guidance coming from the governor's office. As the weather gets warmer, I imagine that the, already intense pressure to have an announcement out will only grow. So yeah, I think you have to sit tight on pools until the governor comes out with whatever he's going to come out with.
And Chris, I have one more question for you. I think this is important for our board members. With regard to their D&O coverage, should they make a decision to utilize facilities in light of the governor's orders. We should perhaps discuss that there is exclusions on D&O for that virus and
Well,
decisions made.
Yeah, and again, Barbara, I have to announce that you really need to talk with your own
Right.
counsel on that one. The problem, and your insurance advisor on that one. Just again, based upon what we've heard here on the LAC through some of our members who are in the insurance business, that there is no coverage for something like that. So unfortunately, in this environment, I think part of your decision-making has to be that insurance aspect. So that would be the first thing I would suggest that you do. I don't think gyms should be opened still in your buildings. You see, even on normal times, people don't clean equipment. What's going to change their attitude unless they've really gotten the message? But I do want to mention one thing, and I'm happy to provide this. South Carolina has its pools open, and they've got a whole host of guidelines that they issued. And I'm happy, I'll send this over to June so she has the link. Share that with anybody who may request that.
Chris, can you speak real quickly to whether or not a common interest community is required to open their facilities if the governor lifts the restrictions, or is it still a discretionary decision on their part based on all available information?
My opinion, George, would be unless it specifically says in the order that all private pools and gyms and the like have to be open, I think that would still be left to the discretion of the individual common interest community. And it should be. I mean, we shouldn't be told by government what's best for our private community.
So, Chris, for communities that have tennis courts, these are private, not a tennis club. So the associations, are they permitted to actually open their tennis courts or not?
Well, if you're looking, there's some towns up north I know that have already allowed public courts to be open. If any of our viewers, including those on a LAC, if you Google, I think it was Burlington County official talking about tennis court reopening, kind of funny the way that she's fumbling over how tennis balls should be taken care of and marked. But to me, I don't know the science behind that. And that's a concern for me. I mean, of course, if you're going to have your tennis courts open, Barbara, no more than singles, because how are you going to social distance playing doubles? And I don't know the science behind the virus that even if you're wearing gloves and you're sweating and you're wiping your face and you then touch that ball, same person's touching that ball. Unless you're doing something that if it's out of bounds, you have your own ball and if it gets hit. So I'm still not comfortable with that until I get more and I hear more guidance from New Jersey on that one. I just don't know the science behind the virus on a tennis ball.
I think the question is more, is the association considered the same as, a tennis club, a homeowners association and their amenities?
Well, again, the answer is I don't know really the answer. They're both private, of course. So unless there's an order that comes out that says specifically all private clubs will be open, subject to, these sorts of sanitation, whatever the restrictions are, I don't think it applies to us yet.
Thank you.
Sure.
Okay, next up, we have Mike Pesci from Associa Community Management Corp., who will speak on remote attendance at meetings.
Thank you, Barbara. And thanks for the opportunity to speak to all of you. By the way, Michelle's got her dog shaking in the background. My neighbor picked this morning to cut the lawn. So if you hear some disturbance, my apologies. And just a quick editorial comment before I get into the substance of this law. I've been honored to be on the Legislative Action Committee for, I think, about 25 years. And I think it's fair to say that we've got a pretty competitive industry within each of our given professions. But on the LAC, there is no competition. We're all rowing in the same direction. I challenge anybody to come to a meeting and see any personal or company agendas rear their ugly heads. It's just a pleasure to work with the people who have historically been on it, and they change from time to time. That they'll have to carry me out. But it is a real credible group of people working on your behalf. Okay, remote meetings. I will tell you that those in my office would find it rather ironic that I would be speaking about technology in any respect. When we talk about remote meetings, There isn't a platform that we've been on that I haven't had some problem getting on initially. But I wanted to talk a little bit about the legislation and then talk a little bit about, maybe perhaps some practice pointers on how to deal with it. So when all of this happened and the stay-at-home order got put in effect, I think the initial reaction of our community associations and boards was, well, there's nothing that we have to do immediately. Let's just hunker down and only deal with emergencies. In short order, that became something that wasn't viable, and we needed to have some process. And I think it's also fair to say, I'm going to talk in a moment about the law that permits us to now conduct meetings remotely. I think many, if not all of us, before that was even passed, started doing it, because what was the alternative? We either had to have no meetings at all and therefore not conduct business at all, or we had to do it remotely because getting together was no longer a viable option. So that was kind of in the category of ask for forgiveness, not permission. But the good news is on April 14th, the legislature recognized that problem, not only for us, but for all nonprofits. So there is a law, the Nonprofit Corporation Act, Title 15A in New Jersey, was amended and signed by the governor on April 14th. For those of you who want to follow the legislation, it was S2342. And it now provides that meetings of nonprofits can, in fact, be conducted remotely, subject to 3 criteria. One is it only lasts to the extent that the state of emergency lasts. So there is a sunset on this. Number 2, you must have guidelines that dictate how you're going to do it. And number 3, it must provide that each member participating remotely has a reasonable opportunity to both participate in the meeting and to vote to the extent that they're eligible to vote. So just an editorial comment on each of them. Only during the state of emergency, I think what many of us have learned during all of this is meetings can be effectively conducted without sitting across the table from somebody. Obviously, not perhaps as well, but it may well be that when all this is over, it may well be that some of this, and we'll have to talk about this as an industry, maybe we ought to be lobbying for some of this flexibility to remain. Because, as opposed to, a manager or a lawyer or a consultant spending an hour and a half in the car driving somewhere, it may be more productive for them to dial in. In terms of the guidelines, I can tell you, I think everybody's been slow picking up on this. I don't think this is a big deal, but it's important. Adopt written guidelines as to how you're going to do it. I think it just needs to be a half dozen bullet points, what platform you're going to use, how you're going to notice it, what participation you're going to allow from the members that are dialing in or logging on. And in terms of member participation, just a thought there, I think we've got to distinguish here, and I frankly haven't talked to anybody else amongst the panel on this, but I think when it talks about members participating, I think we have to distinguish between open board meetings and unit owner meetings, because I think an open board meeting, I think the members that have a right to participate are the members of the board, and for a unit owner meeting, I think the members who have a right to participate are the members of the association. So that I don't think this is suggesting that an open board meeting that the unit owners have a right to participate necessarily, because I think, as everybody knows, under the Open Board Meetings Act, the Sunshine Law, they don't have a right to participate today. I think most of us in a normal environment do, in fact, invite that participation, because it's not terribly politic to invite members to a meeting and tell them to sit there, listen, and please don't open your mouth. However, under these unique circumstances, I think, particularly when we talk about for very large associations, is it practical to permit a level of participation? We've certainly had some associations that have had open board meetings and not allowed participation by the members. That obviously can be dealt with case by case, and again, with the advice of your counsel. But at a unit owner meeting, it's very clear that there must be a method for participation by the owners. So if you're going to conduct an election, as many of us are now either doing or have done or will shortly do, there has to be an opportunity for participation by the members of the association in that election process, or a substantive vote on a special assessment, whatever else is going on. A couple of other thoughts in terms of some experience, and most of these are born out of mistakes made along the way. If you're going to use a remote platform, make sure you test it before you start, because none of them are glitch free, and a glitchy platform can be the difference between an effective meeting and a disaster. When we're talking about meetings where there's significant participation, my suggestion is that the facilitator of the meeting not be an active participant in the meeting. You know, how many of us have watched a guy who's trying to facilitate the meeting and be the board president at the same time on the phone with somebody who can't get his, you can't hear what's going on, and he's trying to talk to two people at the same time. So to the extent that you can separate functions, I think that's important. With regard to election meetings, and I think Dave, or perhaps one of the other participants touched upon the now Radburn reg that says that we must count votes publicly. You know, I thought we had come up with a pretty good solution to, before the Radburn regs came down, to how do we do this remotely. And it was, you know, sit one person in a room by themselves and open up the ballots, and then have two more people on a Zoom or a GoToMeeting platform looking at them, such that you'd have three judges who could report the results of the election out. Now that we must do it publicly, I guess the answer is everybody now gets to watch that one person opening up the envelopes. However, I think we have to reconcile how do we deal with that issue, and the fact that these new Radburn regs also say that votes must be anonymous, because many of our communities already had anonymous voting, but many did not. So we may be opening up these ballots that not only indicate who they voted for, but whose name is at the bottom, the voter, and how do we do that in a public, open sort of way. And finally, a small issue, but with regard to transition election meetings, communities that are in transition from the developer, there are strict timeframes per the DCA pred regs on that. Those transition election meetings, typically at 25 and 75% of sales, must be conducted within 60 days of that trigger closing. And the DCA, I think, was somewhat lax in enforcing that initially during this pandemic. But I think now that they're looking for us to do it. Obviously, we need to do it remotely. And I think anybody in that situation would be well advised to consult with the DCA as to what they're prepared to permit and not permit for each of these meetings, because you know, it is a minefield. And as Dave said earlier, you know, pred does provide for fines. If that's not done well, those fines may well have been intended as opposed to the ones for volunteer board members. So those are my thoughts.
Thank you, Mike. We do have some questions. Do the guidelines for virtual meetings need to be done as a formal resolution?
You know, as most everybody knows, I think I'm a manager, not a lawyer. I believe that it's cleaner if you do it as a resolution. You know, the primary purpose, I think, of doing things by resolution is that they're easily findable, as opposed to, you know, put the guidelines in a set of minutes that nobody can remember. Was it March's minutes, April minutes, May's minutes? If you put it in a resolution, you go to your book of resolutions, or in today's world, in the folder for resolutions, in the entity folder for your association, and you pull it up. So I think that it is well advised.
One other one. Is it only membership meetings, such as your annual meeting, that sunset, or board meetings, can they continue virtually after this?
I believe
after
it applies.
The state of emergency?
Again, I would defer to my learned colleagues. I believe it's all of the above. Any meeting that previously had to be done in person can now be done virtually, and all of that is subject to the sunset when the governor's order is over.
And so, Michael, in respect to that sunset issue, then wouldn't it be advisable for associations to consider amending their bylaws to permit remote participation at meetings, so that it doesn't? They'll have the ability to do that even after the law itself sunsets.
Yeah, clever. Why not? Because at that point, you don't have to worry about guidelines having expired with the governor's order. It's still in effect if something changes and it's extended beyond that. Makes sense, George.
Great. Thank you, Mike and George. Next up is Matt Earl from Cates, Nussman, Ellis, Farhi, and Earl, who will speak on remote notary services law. Hi, Matt.
Good morning. So normally I would like to start with a hilarious joke, but since I can't hear your laughter or see you, I'm not going to do it because it won't gratify me. So this is what you came for, remote notarial acts. I can summarize it in one line, which is that, traditionally notaries, you had to be in their physical presence for them to notarize a document. Now you can do it over Zoom or Skype. But I am going to go through some of the specifics of the act, and it's pretty brief. Basically, overall, that the notary has to get on a remote communication that they can both see and hear the person and vice versa. So it has to be done by either Zoom or Skype or some other method like that. And then they have to confirm the ID of the person. And if the notary personally knows the person, that's enough. Or they have to have two forms of ID instead of one, which was what was traditionally and legally required. So if you're doing a remote notarization, you need two forms of ID, and you show them to the screen, and the notary confirms that it shows that that's who you are. Alternatively, if the person doesn't have ID available, a person can appear before the notary in person and under oath vouch for the identity of the person doing the remote notarization. So that's an option if somebody for some reason doesn't have ID. And then the notary has to confirm that the document that's going to be signed by the person over in their house or their room is the same as what the notary is looking at, right? So the notary has to ask the questions. What do you think you're signing? Is this a deed or whatever it is? And they have to go through that process. And the notary has to make sure that the notarial certificate, whatever the notary is signing, indicates that it was done via remote communication. Everything has to be recorded, and the recording has to be kept by the notary for 10 years. There's some exceptions to what type of documents can be notarized remotely. The two exceptions are, one are family law matters, so you can't sign your adoption papers remotely. That has to still be done in person. And secondly, there are certain provisions of the Uniform Commercial Code that are governed by the Uniform Electronic Transactions Act, and that already has provisions for remote notarization. So some of those provisions are excluded. None of that really matters that much for condominiums. I think the part of this that affects condominiums or cooperatives, are that liens and deeds and other documents that we use regularly in this business can be remotely notarized. If you're a notary and you want to get into the weeds on it, which you probably don't, but if you did, the Treasury Department has put an appendix to the notarial handbook that exists in New Jersey with some procedures for executing documents via like DocuSign and having those notarized, and there's certain procedures they've adopted for that. And then they have a very clear step-by-step guideline. So that document is available online. It's easy to find if you put in New Jersey notarial notarization guidelines or handbook. It's the notary handbook. So that's it. I mean, I'm sure there's tons of questions about this. So
Thank you, Matt. Okay, we're going to move on to Dave Ramsey, who already briefly spoke about Ukiah. I did have a question, Dave, that you might just explain what the Ukiah bill is, and you're going to speak also on the statute of limitations on construction defects.
That's right. And Barbara, I probably totally confused you because a last minute change to the agenda. I was originally supposed to speak to you about Ukiah at the same time as Radburn. And I noticed when I looked back at the new agenda that I wasn't. So I kind of blew through Ukiah, and I will come back to it right now. So sorry for confusing you. I think almost everybody knows Ukiah stands for the Uniform Common Interest Ownership Act. It's a real mouthful. And it's a bill that went through an almost 10 or 15 year period from the mid-90s through 2010 with CAI trying to get it adopted. It had brought out a lot of people who wanted to push associations to go much further than the protections that were already in Ukiah for homeowners, which were substantial. And after going back and forth forever, we finally said, look, this would actually improve homeowners' rights, but if we're going to keep fighting with people who want to make it an unfair burden on associations, we'll just give up and go nowhere with it. Well, come forward 10 years, and the Uniform Law Commission came to us and said, hey, we still think this is a really good bill and we should really still do it. We said, we'll do it, but only if you only introduce the 2 non-controversial articles of Ukiah, how to form a community association, how to terminate a community association, things of that nature. And then we can deal with other issues one by one later on. Curiously enough, Ukiah seems to be like a rumor magnet. So rumors started circulating last year about it. One was that if Ukiah was adopted, everybody's taxes are going to go up. Well, quite to the contrary, Ukiah adopted the provision of the Condominium Act that says you can't tax the common property, even if you're in a homeowners association, just like you can't tax the common elements. That's all part of the value of the homes that are already there. So it would, in those towns that taxed homeowners associations for their common property, and they do exist, they would no longer be able to tax those homeowners associations. Then there was a rumor that the age restriction in age-restricted communities would go away because of Ukiah. That turned out to be, of course, totally fake. Ukiah has been adopted in many states throughout the country, and all of those states still have age-restricted communities. And CAI, of course, supports age-restricted communities, would never do anything that would harm their interest. Lastly, there was a rumor that Ukiah mandates that every association has to have a professional management company. While we certainly endorse the idea of professional management for community associations, there's nothing in Ukiah that mandates that associations that are self-managed, which apparently in certain areas of the state, there are a fair number of them, have to go to professional management. So we kind of fought back all that. We got the legislature to adopt it. At the end of the day, when the governor vetoed it, we did have a meeting with the DCA before the governor vetoed it. We said, look, you never came to us before. Tell us what your problems are. If they're reasonable, we'll be happy to attend to them. And the problems were definitional. I mean, their problems were, well, Ukiah calls it the declarant. We call it the developer. I mean, it was literally those kinds of minor, trivial kind of changes. What we really kind of came to believe is the DCA just wanted to be an old dog that wasn't going to learn new tricks. They didn't want to have to deal with learning a new law. And on that basis, they told the governor it was unacceptable to them. The governor did veto it and say to us, he still thinks it's necessary to have a new law. He still thinks it's a good idea, but we should try to work things out with the DCA. Well, of course, we would love to do that. The problem is with the pandemic, it's very hard to have meetings. I know, Michelle, that you're interested in facilitating that. If you have any comment on it, feel free to pop in and comment on it. But go ahead.
No, just as you said, I mean, we're in this strange situation where we really do need to sit down at a table and hash out definitions and whatnot. And we just can't do that right now. Also, I think the DCA staff has been, busy trying to respond to, they're dealing with having to transition to work from home, and also have to do the state functions in responding to the pandemic. So, it is difficult at this point in time, and it certainly stalled things a bit.
But David, it's fair to say that we do want to meet with our friends and colleagues over at the DCA and work out some of these obstacles that are in front of this bill, and let's hope that it works.
And we were willing to do that before the bill went to the governor. We're willing to do it today. And frankly, when things calm down just a bit, even if we're still home, we're more than happy to do a Zoom meeting with the people at the DCA. So, you know, we're there, we're ready to talk, as we've always indicated to DCA that we are. So we expect that we'll go through probably both houses of the legislature again, and then it's going to be important that, you know, prior to that happening, we have a chance to really figure out what's the problem. So that said, let me turn to the bill dealing with statute of limitations. And this will be particularly meaningful to associations that might be in the transition process or might go through the transition process. Several years ago, I guess I'll call it notorious, decision came down from the Supreme Court on statutes of limitations. It was a very unusual fact pattern. An association in, I believe it was either Edgewater or Fort Lee, called Old Palisades at Fort Lee, was created initially by the developer as an apartment complex. But the developer ended up selling the project to a new buyer who turned it into a condominium. The developer sold units in the condominium, and eventually the owners took over control of the association. Of course, they did what most associations do, which is to have an engineering study done. And they became aware of quite a few significant construction defects in the property. They filed suit. The defendants in the case claimed that they were outside the statute of limitations. Now, I know this is a little bit in the weeds, but let me spend a minute on this. Statute of limitations says that an association has 6 years from essentially from when it knew or should have known it had a claim. That known or should have known is known as the discovery rule. In other words, you have 6 years from when you know that you had a claim to file it. Now, of course, the association is a continuing entity. The developer controls it for any number of years until the developer turns it over to the unit owners. In the past, and there's even a couple of judicial decisions on it, the courts have said, well, equitably, you really can't have that statute of limitations running until the owners get control, because the developer has no interest in suing itself. Hence, it is not going to bring a claim for the association against itself. The Supreme Court, in its ultimate wisdom, said, well, that's all very interesting, but it's a corporation. The corporation either knew or didn't know at a certain period of time that there were defects. In this case, there were evidence that the developer knew that there were defects more than 6 years before the case was filed. And the Supreme Court says the rule on discovery doesn't change because this is a condominium. That came as a surprise to almost everybody in the industry who had relied on the old decisions. And as a result, we have gone to the legislature and asked the legislature to fix this, and to fix it by making clear that the statute of limitations, the 6-year statute of limitations, cannot, in a community association job, start to run until the board takes over control of the association. We have a sponsor for it, or we believe we have a sponsor for it. This has kind of fallen a little bit to the back because of UKIWA, because of the pandemic, because of the debt collection bill that George went through with you. So there's been a lot of priorities that we've been dealing with at the LAC level, but this has not disappeared from our list of things we need to get done. And we are hoping that as things calm down a little bit, we will be moving forward. Michelle, do you want to add anything on that?
No, just that in terms of moving forward, the legislature put regular committee meetings on hold pretty much from March. Quite frankly, I think the Senate Community and Urban Affairs is one of the first, if not the first, regular committee that's hearing bills next week. And this is the committee where the UKIWA bill is. So yeah, we've been in contact with Senator Weinberg. You know, we need to, you know, she will move it forward. She understands the urgency of this, but process right now is slowing us down. So,
thank you, Michelle. And Barbara, I'll turn it back to you.
All right, thank you, David. Next, Mike Pesci is going to talk about the DCA inspection law.
Thank you, Barbara. Nice to talk about something that's not coronavirus related, I guess. So the good news is, first of all, those of you who govern or are involved with single-family detached home communities can tune me out at this point, because this law does not apply to you. The amendment to it last year still doesn't apply to you. What it applies to is multiple dwellings, regardless of the form of legal ownership. You know, I think the good news is that the DCA, who administers this program, has in fact put physical inspections of our communities on hold during this pandemic. The bad news is they apparently spent the time to finalize the Radburn regs, so that you know, talk about an unsilver lining. So just by way of quick background, starting in 1967, a law has been on the books that requires multiple dwellings within the state of New Jersey to be inspected by the Department of Community Affairs through their Bureau of Housing Inspection. Historically, it's been every 5 years. So that was the change that was made last summer, specifically in August of last summer. A bill initially started that would have reduced that 5-year inspection cycle to 2. And those of us who, you know, are involved in these inspections on a routine basis for our communities, it's painful enough every 5 years. 2 years would have been, you know, absolute murder. So that got a lot of objection and opposition, not just by us, but as you might guess, by the apartment house industry and whatnot. And when all was said and done, the law that was ultimately passed, I think, is an improvement and a benefit to us. Well, what did it do? Now it's no longer a 5-year inspection cycle, but rather the inspection cycle varies depending on how quickly you abated the violations in your prior inspection. So that, and the options now are, if you behave very well and you abated those violations either initially, and by the way, nobody ever gets a clean report, you know, right out of the blocks, or after the first reinspection, your next inspection is 7 years hence. So the most well-maintained responsive associations actually will now get 2 more years between inspections. If you don't abate until the second or third reinspection, your next inspection will be 5 years hence. So no change from the status quo. And for those who can't get it together and don't abate until after the third reinspection, they in fact will be reinspected every 2 years. So I think there's some symmetry to this now. There's some fairness to this now. It's attempting to you know, give the well-maintained associations, which are, you know, the overwhelming number of community associations in our industry, a benefit by extending to 7. And for the bad apples, they're going to have you know, the big brother state looking over them more often, which is probably appropriate. And for everybody in the middle, no change, still 5 years. Just a few, and I'll try to run through this quickly. Because believe it or not, I'm passionate about this topic that I think puts most people to sleep. So I just wanted to talk a little bit about some of the ins and outs of the inspection process, and I'll run through these very quickly. First of all, know that there's a fee due for the benefit of the state coming in and inspecting you, and it's a sliding scale per unit. It goes down per unit as the communities get larger, but it's not insubstantial. You know, for a 100-unit association, the fee is $1,600. A 500-unit community, the fee is $6,400. So it's something that needs to be budgeted for either in the year when it happens or over time. Second, there are a couple of, on its face, exceptions or provisions that would seemingly affect us, but in practicality, at least from my perspective, have not. The first is there's a provision that enables an association to adopt standards for self-inspection by condominium associations, which are at least 80% owner-occupied. That was intriguing when that was first put in the law. However, as an industry, and CAI representing the industry long ago determined this is not something that we really want to engage in, because we may or may not like the state coming in every 2, 5, or 7 years to look at us. But the idea that we would do these inspections on our own and then be liable for anything that was missed was more exposure than we thought was appropriate. So it was a pick your poison situation. Second of all, the law also provides that if an inspection reveals, and I'm quoting now, a consistent pattern of compliance with the maintenance standards in at least 20% of the units, then the inspector may cut the inspection short and not bill you for the other 80% and not conduct the inspection for the 80%. I've been doing this 30 years. Not once has that ever happened. So, and I'm not holding my breath. And finally, there is an exception, however, that is meaningful. And that is, depending upon the structure and the composition of your building, and this applies primarily to townhouse sections, you may well be eligible for an exemption that takes you out entirely. However, and time doesn't permit today to go into it, but you really ought to look at the section. It has to do with fire separation walls between sections. It does have a requirement that the section be owner occupied. Go figure. Talk about a moving target. The important thing about seeking that exemption, though, is you must do it before you get the notice that the state's coming in to inspect, because once they give you that notice, it's too late. So it's typically we look at it after an inspection saying, why don't we do it now? And finally, know that when you get the inspection report, there is an opportunity to contest it. There's also an opportunity to seek adjournments or extensions of time to comply. Please know, especially with respect to the ability to appeal, it's within 15 days of your receipt of the report. It's very time sensitive, and you can easily slip up there if you're not paying attention. So thank you.
And Mike, one thing, if you do ask for the extension instead of appealing, that means you agree that violations are valid. So if you get one of those things, maybe talk to your attorney right away. I think you're usually better off just appealing and then working it out after you've appealed.
I agree.
Thank you. Next, Matt Earl is going to speak about electric vehicle charging stations.
Thank you, Barbara. So several years ago, the industry groups that consist of the manufacturers of electrical vehicle charging stations and the manufacturers of electrical vehicles like Tesla and ChargePoint and all these groups drafted model legislation that requires community associations to permit owners to be allowed to install car charging stations in their designated or owned parking space. And designated really just means assigned. It has the association assigned spaces to people. And the bill, the uniform bill that they prepared is very harsh towards associations. It doesn't give the board any discretion. It does not have very many protections for community associations. There's a number of issues with the uniform bill, and there have been bills passed in California and in Oregon, introduced in New York and a bunch of other states. And the uniform bill was introduced in New Jersey, and it was introduced by Assemblyman Gordon Johnson. We didn't like the bill. We understood that a bill would likely be passed one way or the other, but we wanted to get a seat at the table. We were fortunate that Assemblyman Johnson was receptive to our issues, and we had a number of meetings with his chief of staff and the representatives of the builders group and the representatives of the charging station groups, and we were able to get the vast majority of the things that we requested be put in the bill. We couldn't change the fundamental nature of the bill, which is that unless there's a good reason, an association has to permit an owner to install a car charging station in an assigned spot. But we were able to craft the bill in such a way that we feel that it's something that we can support, knowing that something will be passed and that will have adequate protection for owners. So I'm just going to go over a couple of the key points of the bill. It permits associations to impose reasonable rules and regulations relative to car charging stations. The stations have to meet all applicable health, safety, zoning, legal requirements. The owner has to apply. If in general in your association, owners have to apply for alterations, and that's most multifamily associations. Then they have to apply for the car charging station. There has to be a response by the association within 60 days. but we built into that the association has the right to require the owner to pay all review fees, such as engineering or electrician, legal fees. All that has to be paid by the owner. And the association required that to be paid in advance. So you don't have to worry that, is this guy going to pay or not after we hire this engineer. The stations have to comply with reasonable architectural standards. The owner has to use a licensed professional to install it. They have to pay for all the electricity. The application can be denied if could be a life safety risk, meaning if there's some reason why this could damage the electrical infrastructure or cause a fire, the association could deny it. We actually had to fight to get that put in there. The car charging station people did not want that in the bill. They thought it would be a good excuse for associations to deny these, but we got it in. If the charging station will require electrical infrastructure upgrades to the common electrical equipment, like new electrical panels or things like that, then the association can issue a special assessment against all the owners who have car charging stations or who have applied for car charging stations to cover the cost of that infrastructure upgrade. Any money owed under this electrical car charging regime will be deemed to be an assessment that's collectible in the same manner as any other assessment, whether that's putting on a lien or so on. The owner has to maintain the station and pay for its maintenance and pay for its removal. The owner, if he sells and that parking space goes along with the sale, has to inform the new owner of all these requirements and the fact that the car charging station exists. The owner has to carry at least $100,000 in liability insurance or whatever higher limit the association normally requires for owners to carry in general via the governing documents or rules and regulations. So in essence, part of this bill says, hey, an association can probably have rules and regulations requiring owners to carry homeowners insurance. And the owner has to hold the association harmless. So all those provisions apply when a car charging station is installed by an owner in a space for his or her exclusive use. This also gives the board, in its sole discretion, to license common area parking spaces to owners for the installation of a station. So if the owner is assigned space, it wasn't practical to install a car charging station, or if there were no assigned spaces, like first come, first served parking or something like that, the board could in fact license spaces for car charging stations. The association now has the right to install car charging stations for common use and adopt appropriate rules and regulations. And they can create new parking spaces to facilitate the installation of charging stations. So, notwithstanding the governing documents, now a board could, if it had some extra space, create a new space for installing a car charging station. And last but not least, the act does not apply to commercial unit owners or commercial parking. So if you had a mixed use condominium, we had concerns that if a business sprung up and they wanted to install 20 car charging stations to be the business, we wouldn't want to have this act apply to that kind of scenario. And two other things I'll mention. One is that the original bill had a number of punitive provisions about fee shifting, legal fee shifting. If there was a lawsuit and the association had to pay the legal fees, and there were civil fines and penalties for violating an owner's rights under the act. We had all that removed. We felt that it was unfair to have to litigate, in that manner if there was a legitimate dispute about the car charging station. So the bill, there's a Senate bill and an Assembly bill. The Assembly bill is A3367. The Senate bill is S1951. Both of those are pending. We're optimistic they will be passed, and we think this will actually be a benefit to community associations. Thank you.
Okay.
Thanks, Matt.
All right. I do have some questions. That concludes the various today. I do have some. One is